Okay, good morning, Year 12. After my kind of impromptu lesson, it was kind of a test to check that it all worked, I decided that I would continue with making some more videos just to give you an idea of the direction you should be going in. And then hopefully, once my set of videos are done, you can complete some of the worksheets and complete some of the things that you need to know and the additional reading that you need to do by yourselves, which I'll go through that later on, possibly in a different video, whenever. Today I'm going to be looking at important Supreme Court cases that you should know and that you can use not just as a case study for the Supreme Court, but you can use it as case studies for lots of different subjects when you're in your exam. So, for example, you could use it as a constitutional example, or you could use it as an example of judicial review. Well, that's Supreme Court. You could use it as an example for where the checks and balances take place, so something like that. So I'm going to give you some of that information. It will probably take me quite a while. Just so you can follow along, this is the VLE. Let me go back home. So this is a page that you get to when you go through the system. And where I am currently going from is Government and Politics, Year 12, because that's you, Findlay, because that's me, Supreme Court, because that's the subject we're doing, and then I've just uploaded this one here, Supreme Court Cases Over Time. That's the PowerPoint I'm going to be going through today, and the information on the PowerPoint is obviously on there, so you don't need to write it all down separately. You can access it, but I would suggest using it to create possibly a table of case studies that you could use for different sections, or possibly mind maps of case studies that you could use. Something like that would be incredibly useful, I think. Yesterday, the video I did was from this PowerPoint. I will be going back to that, but we've kind of paused that because I thought this was more important for you to be doing at the moment and something that you can get written down. So here is this PowerPoint. I would full screen it. 1 second. Let's make sure it's on the right place. So I don't want to use timings. Do it on the primary monitor. Don't want presenter view. There we go. So these are the important Supreme Court cases over time that you should need to know. The one thing, the way that they're going to be done is I'm going to tell you the name of the case and the date is always going to be at the top. That's what you can use in your exam to point towards. If you write that down, Marbury versus Madison 1803, then that's important key knowledge that the examiner will be looking for. I'll give you a brief idea of what the case is about, and that's not necessarily the important bit. The important bit is the decision, usually, because that tells you what the case was and why it was useful. So, I would also say that this information does actually come off a website, which if you Google important Supreme Court cases over time, it does come up with this stuff. But there's 45 of them. You don't need 45. So I've picked the most important ones and the ones that are good to use as case studies instead of doing all of them. So, Marbury versus Madison, 1803. They go in chronological order, so you should be able to follow along. So, this is where William Marbury, who was supposed to become the Justice of the Peace in the District of Columbia, but Thomas Jefferson and James Madison, mainly James Madison, blocked it. They wouldn't validate the appointment, and so Marbury sued him. And it went through all the courts, and it ended up in the Supreme Court. And the justices ruled unanimously that Madison's refusal was illegal, and that the law that Marbury had sued under was also unconstitutional. So it was like a double whammy from the Supreme Court. This meant that in the future, the Supreme Court had the power of judicial review to decide whether a law or executive action was unconstitutional, and this gave the High Court the legal authority for every single decision it would make in the future. This is why it's important. So this case, if you want to boil it down, this case means that the Supreme Court has the chance to do a judicial review every single on things that are constitutional or law-based. So very, very important case, and the first one that gives the Supreme Court the power that it needs to do the further cases. Next one is about civil rights. This is Plessy versus Ferguson. The reason why I've put this one in is because it's kind of a misstep, and it's something that you can point towards as the Supreme Court, even though they create these conventions and they create this precedence, it can be undone. So Plessy versus Ferguson was about Homer Plessy, who was a black person in Louisiana, and he boarded a train and sat in a car that was only for white people, and he refused to move, and he was arrested. And he argued that the Separate Car Act, which required all railroads to provide equal but separate accommodation, was violating his rights under the 14th Amendment's Equal Protection Clause. And the Supreme Court said that separate but equal accommodations for whites and blacks did not violate the 14th Amendment. So the 14th Amendment means that everybody should be treated equally. Essentially, it's about equal rights. And this court case says that separate but equal does not violate the 14th Amendment. So it means that segregation is legal. Okay, so you can have a school, for example, that is only for white children and a school that is only for black children, as long as they are both equal in quality, so to speak. The only person that went against it was John Marshall Harlan. He was the one, and he was known as the Great Dissenter. He wrote that the Constitution was colourblind and that the US had no class system, and therefore there shouldn't be a dominant ruling class of citizens. So it should be colourblind, and the classes should be equal. But separate but equal lasted for about 60 years after this, and it was only got rid of in another court case that we'll look at in the future. So this kind of sets up the precedents where actually the Supreme Court can rule on previous rulings and say actually that was incorrect. So we'll come back to Plessy versus Ferguson in a bit, but very, very important case that you need to know about. Book versus Bell. This is 1927. This was a woman who was diagnosed with feeble-mindedness. She had a low IQ, essentially, and she was committed to a state institution after she was raped by her foster parent's nephew and had his child. Her mother had also been diagnosed as feeble-minded as well, and under the 1924 Virginia Eugenical Sterilization Act, she was to be sterilized against her will, so she wouldn't be allowed to have children ever again, as she was seen to be unfit to procreate. Okay, unfit to have children. Her guardian obviously sued, hoping to have the Supreme Court find sterilization unconstitutional. Sorry, that should say unconstitutional. I'm going to check. I'm going to change that before I don't get that wrong. Back to the slideshow. There we go. And the Supreme Court held 8-1 that there was nothing in the 8th or 14th Amendment that said Carrie Buck could not be sterilised. So nothing in the 8th or 14th Amendments that said that she could not be sterilised. So she should be sterilised, basically. It's better for the world if instead of waiting to execute degenerate offspring for crime or let them starve for their imbecility, society can prevent those who are manifestly unfit from breeding their kind. This is less than 100 years ago. So this case, again, until the 1960s, more than 60,000 people were sterilised because of this case. And technically, this case has never been overturned. So it's something that is still a precedence that the Supreme Court set. So again, this is a good example of where the Supreme Court can rule on things, but actually it is possible for law and general attitudes towards it to move on, but the case is still there and it's still operational technically. Sterilisation has now stopped in America pretty much completely, but this case is still sovereign, still there. So I think it's a really good example if you wanted to talk about how the Supreme Court doesn't. For example, you could get a question on the U.S. Supreme Court has too much power. How far do you agree? This is a good way of saying, well, actually, even though this case is still there and still not been overturned, it's not used. Therefore, the Supreme Court has less power. If you know what I mean. So it's a very good case to put in for that. Got Brown versus Board of Education, another civil rights case. This is after Plessy versus Ferguson. So we're back to Plessy versus Ferguson. In the 50s, Linda Brown had to take a very dangerous route to school. Her blacks only school was, I think it was about 5 or 6 miles away from her house, through a very, very rough neighbourhood. And there was a white school that was actually within a mile from her house, which is much better for her. Different direction as well, so she wouldn't be walking through the area that was a problem. And so Oliver Brown believed that this was a breach of the 14th Amendment, which says no state can deny to any person within its jurisdiction the equal protection of the laws. And so Brown, as well as a few other parents under the NAACP, which was the civil rights movement, the kind of law arm for the civil rights movement, sued and took it to the Supreme Court. And the Supreme Court ruled in the decision that separate educational facilities were inherently unequal, and it meant that the lower courts and school boards should proceed with desegregation, and this got rid of the separate but equal clause from Plessy versus Ferguson. So again, this shows that the Supreme Court can rejudge on the cases that it has already put through, and change essentially its mind, so to speak, if that makes sense. So Brown versus Board of Education displays that the Supreme Court can adjust its attitudes based on the time. Reynolds versus Sims. So this was under the 14th Amendment, each voter's intentions are meant to have an equal weight, but in Alabama, the legislative districts that were drawn up were no longer accurately representing the amount of people who live with them. There was a big influence of population in a lot of the districts, but they didn't have the right amount of delegates and the right amount of weight in the legislative districts. And this issue was breaches the 14th Amendment under the Equal Protection Clause again, and the Supreme Court held 8-1 that Alabama's apportionment scheme, had breached the 14th Amendment, and they ruled that it was a fundamental right and equal participation is crucial. Legislators represent people, not trees or acres. So this made the government more democratic. This is a representation case. So if you want to talk about how voter representation in America has changed over time, or how it is protected under the Constitution and the Supreme Court and the checks and balances, this is a good case for that. So one that's very, very useful about representation. Heart of the Atlanta Motel versus the US, 1964. The Heart of the Atlanta Motel in Georgia refused to provide accommodation for black people, but the Civil Rights Act of 1964 banned this practice. 2 hours after the act was passed, the motel was asked the court to stop the enforcement of clause in Title II, which forbid racist discrimination by public accommodation providers. The motel argued that it exceeded Congress's power. So this is an argument over whether the Civil Rights Act, which went through Congress, was anti-federalistic, if it meant that the Congress and the legislative arm of the American government was going too far, based on the original Constitution. And the Supreme Court held unanimously that the act was not exceeding Congress's power. It reasoned that discrimination by businesses had a massive impact on black people travelling, even when it was small businesses, since negative effects could be far-reaching when added up. And it was especially the case here, since 75% of the guests staying at the motel came from out of state, and this was the first case to challenge the Civil Rights Act, and by upholding it, the act was legitimised and strengthened, and the law would go on to be used to get rid of racist discrimination. So a very good one, talking about civil rights, which we will have to talk about in the future anyway. Okay, this one's a big one, and this one's a very important case because hopefully you will have heard of the Miranda Rights The Miranda Rights are something that Americans are very proud of, and it's something that has been adopted in many countries, including Britain, since this point. So, here's where it comes from. In 1963, the police obtained a written confession from Ernesto Miranda that said that he kidnapped and raped a woman. However, they had not advised Miranda of his right to have an attorney present during the interrogation, and Miranda appealed on the basis that his confession had been gained unconstitutionally. The Supreme Court held that 5-4 that law enforcement should advise and must advise of a witness or a suspect's right to remain silent, and their right to attorney, and that anything that they say can and will be used against them in a court of law. Evidence could not be used in a trial unless the warnings had been given and knowingly waived. Police work and the well-known "you have the right to remain silent" would not be so firmly entrenched into society without this decision. People know their rights, and people know that, and the police know that they have to read them to suspects. So Miranda Rights is a massive case that kind of displays the power of the Supreme Court, but also displays the kind of awareness of the Constitution that people have in America, as it's something that happens all the time. And if you go up to pretty much any American and say, what are the Miranda Rights, they will almost definitely know what they are and will be able to recite them for you. So the Miranda Rights is a big case that can be used a lot across the course as a case study. Brandenburg v. Ohio's 1969. Clarence Brandenburg was arrested after making racist remarks and claiming that the government was suppressing the Caucasian race to a gathering of Ku Klux Klan members in a field in Ohio. He mentioned that the action might need to be taken, and he was filmed by the media that he had invited to the gathering. So he said it might need to be taken, and he was filmed saying it. The state law criminalised advocating violence as a means of accomplishing political reform, and he was sentenced for up to 10 years in prison. The issue, though, and this is the issue, the rest of the case is kind of elementary. The issue, and the thing that you can point towards in your exam, is that whether free speech advocating for violence was protected by the First Amendment. So this is a First Amendment case talking about free speech, something that you can use quite a lot. Supreme Court held per curiam, which means that in the name of the court rather than the judges, because they felt that the judges would open themselves up to be abused or open themselves up to prejudice if everybody knew which way each judge voted. So this only happens really, really rarely, and it happens in cases where it can be quite inflammatory. And instead of saying who voted which way, they did it by the power of the court. And they said that Clarence Brandenburg's free speech had been violated. It said that speech may only be outlawed when it is directly inciting imminent lawless action. So because he said it might need to happen, because he said it might need to take action to protect white people's rights, that isn't an imminent lawless action, and therefore it's free speech. It also found that abstract discussions similar to that are not the same as an actual preparation to engage in violence, and this broadened the protections for political dissent. It broadens how far free speech has a grip on America. This is completely different to Britain. So if you want to make a comparison to Britain, we have hate speech laws, and hate speech laws basically can be interpreted in whatever way people want, or they are, well, what I want to say is they're basically open to interpretation. And so in Britain, our free speech and what we can say is much more limited to America, and that's mainly because of this case, and this case opens up how far free speech can go and how far it can be taken. So a very important case, one that you can refer to quite a lot, especially in comparisons to Britain, but also on its own with America too. Roe v. Wade, I would expect most people will know this, but we'll go through it anyway. This was a Texas law that said abortion was illegal unless by doctor's orders it was to save a woman's life. An anonymous plaintiff called Jane Roe, who was later identified as Norma McCorvey, filed against the Dallas County District Attorney, arguing that the law on this was unconstitutional. And the Supreme Court held 7-2 that overly restrictive legislation around abortion was unconstitutional. Based on a right to privacy in the 14th Amendment, the state was not allowed to regulate a woman's decision. And this overruled any laws that made abortion illegal before a fetus was viable, giving women more power when it comes to their bodies and having children. And it made access to abortion a constitutional right. This is especially important at the moment, because there's a fight going on in the US over abortion rights. It's more last year, but it's still happening, because in 15 states, I think, yes, 15 states have banned abortion after 6 weeks of pregnancy, and this is due to the rights to life issues, and some campaigners on the abortion side of the campaign are saying that actually this goes against Roe versus Wade and calls into question the Constitution at the time, which is a very important thing to kind of incite, kind of say, because if that is the case, the Supreme Court, like you saw with Brown versus Board of Education, will need to resit and look at whether the precedent still works. And essentially, the debate, I think, has been put on hold due to many other issues that are going on at the time. But generally, the Supreme Court will create decisions on whether abortion is legal. So, yeah. That's nicely poised at the moment. There is a BBC article that you could go to. Let me just find that actually, because it will help you. Supreme Court. Here we go. So this is it. I'll scroll down to find it. So what's going on in the US fight over the abortion rights? This is the Supreme Court case. I will. There's the link there which you can find. But if you just Google that will come up. But there's this section here about the Supreme Court and what they've ruled so far already. If I can find it. Oh, I've lost it. Here it is. What will the Supreme Court do? So you can look that up. But here it mentions Roe versus Wade. Which may need to be revisited in the future. And if you've done your Supreme Court profiles, you'll notice that this is quite interesting. That Clarence Thomas says that the Supreme Court will have to act because he is a strict conservative. We're going to talk about what strict conservative means and what that is in a future lesson that I'll upload for you all to do. US versus Nixon. I've put this one in because it's Watergate, something that you can talk about when it's about impeachment and how the Supreme Court fits with the president and what power they have to with the president itself. Essentially, if you're not sure, the Watergate scandal was where President Nixon had recorded many conversations that he'd had in the White House, and the case for impeachment on Nixon had asked for the tapes to be used in evidence in his trial in the Senate. And Nixon refused, saying that he had executive privilege that allowed him to withhold sensitive information in order to maintain confidential communications and to maintain national security. This case is the reason why Trump had to give over some of the transcripts of his calls to the initial impeachment trial, which is quite interesting. Nixon originally released edited versions, but not the complete tapes, leading to Nixon and the prosecutor both filing petitions to be heard in the Supreme Court, and the Supreme Court eventually held unanimously, so no one dissented, that while there was limited executive privilege for military or diplomacy reasons, it wasn't enough in this case, and Nixon had to hand over the tapes. This case led to Nixon's resignation, and also ensures that the president does not have unlimited privilege to withhold information from other branches of government. Not even the president is above the law. So a very important case, clearly displays the checks and balances on the judiciary and the executive, and displays the kind of power that the president has or doesn't have in this case. Texas v. Johnson. During a protest in 1984 against Ronald Reagan, local corporations in Dallas Gregory Johnson covered the American flag in kerosene and set it on fire. And he was arrested and charged with desecrating a venerated object, which was banned under Texas law, and he was sentenced to 1 year in prison and ordered to pay $2,000. He appealed on the basis that the law was in breach of his First Amendment rights to free speech. And the decision was, the Supreme Court held 5-4 that burning the flag was protected under the First Amendment. In a majority opinion, Justice Brennan wrote, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. We do not consecrate the flag by punishing its desecration, for in do so we dilute the freedom that this cherished emblem represents. If you can't have the freedom, then the flag almost becomes worthless, is what he's saying. Very interesting case. Again, another First Amendment case that you can use as an extra example, but one that is relatively recent, and one that actually got flagged up very recently to do with the Iraq War and under Bush as well, which is worth a look if you wanted to use that as an example. DC versus Heller, 2008. Heller, a security guard who lived in DC and carried a gun for work, was not allowed to have a gun at home due to the city's laws. This is a gun law case. This is one that's very useful when we're talking about the Second Amendment. He thought that laws were too restricting and made it impossible to defend himself. Heller, along with 5 others, sued, arguing that it was a violation of the Second Amendment. They were funded by Robert Levy, a libertarian lawyer from the Cato Institute. And the Supreme Court held 5-4 that the Second Amendment was guaranteed an individual's rights to possess a firearm at home for self-defense, and it was the first time in 70 years that the Supreme Court ruled on the Second Amendment. So this goes against popular feeling about the Second Amendment nowadays, I would suggest, because it's talking about people having the right to have a gun at home. And in 2019, one of the justices that ruled on this case said it was the worst decision during his 34-year tenure, representing the worst self-inflicted wound in the court's history. He said an amendment would have been added to the Constitution to overrule the case to stop gun massacres like what happened in Las Vegas or Sandy Hook. So he's come out and said, after he made the decision, that actually he feels that further massacres, further gun crimes could have been prevented if this case hadn't gone through. So, Citizens United vs FEC, a non-profit organisation called the Citizens United, made a disparaging film about Hillary Clinton, and they wanted to run an advert for it during the 2008 election. But for the Federal Election Campaign Act banned corporations and unions from spending money to advocate during the elections, so the Citizens United couldn't show the film since it mentioned Clinton, who was a presidential candidate at the time. I'm just going to do this 1 second. Supreme Court held 5-4 that corporations and unions can spend as much as they like to convince people to vote for or against political candidates as long as the spending is independent of the candidates. The ruling gave corporations protections under the First Amendment's right to free speech. And even though it was called a threat to democracy, the decisions kind of changed how politics works in the US. In the 2014 Senate elections, outside spending had more than doubled to $486 million since 2010. So this changed campaign spending, changed how spending for private corporations aren't actually connected to candidates, whether they can influence what people believe, and this was found that they could, and therefore campaign spending around those corporations has massively increased after that. Very interesting, and one of the reasons why spending in American elections has gone up which is a good case study if you want to use it. How many more have we got? Oh, it's the last one. Obergefell versus Hodges. James Obergefell and John Arthur, a couple from Ohio, got married in Maryland. In Ohio, the same-sex marriage was not allowed on death certificates. Arthur was chronically ill and he wanted to have Obergefell on his death certificate along with 3 couples from Kentucky, Michigan and Tennessee. They sued their states, claiming that they were in breach of the Equal Protection Clause in the 14th Amendment, which says no state shall deny to any citizen within its jurisdiction the equal protection of the laws. And the Supreme Court held 5-4 that the 14th Amendment guarantees the right to marry, including same-sex marriages. Every state in the US now legally recognizes same-sex marriage. Before this case, 13 states still had a ban. So this is a same-sex marriage case. Again, about 14th Amendment, but also can be used as a symbol of the Supreme Court and its power. So that's all of them. I would suggest make your mind maps, put the cases themselves into categories with what the case is and then what amendments it refers to, what parts of the Constitution it refers to, what kind of current issues that it refers to, and so you have those things to draw on as revision as well as we can draw on them in lessons. That would be my main task for you to do in today. The other thing I wanted to go back to is the some of these sheets. Some of these sheets are just extra reading for you to do. Some of these sheets are that's not very well formatted. It's because I've not downloaded it. But some of these sheets are like comparisons for you to have that you can take and make as well, I suppose. And there are some worksheets as well. These are by the book. You can find the pages if you have the book. If you don't have the book, what I would suggest is let me know. I can't photocopy at home, but there is a chance that I'm going to be working in school relatively soon, so I may have access to a photocopy in the future, so I may be able to get pages that you need. So if you tell me the pages you need, I may be able to get you them. If not, if worst comes to worst, then we can do pictures of them. So that's there for you. I've gone through the important Supreme Court cases over time. Tomorrow, so I'm not going to do any more today because I don't expect you to do more than one lesson every day. Tomorrow what I'll do, no I don't want that, is I will go back to this PowerPoint and go from the stage that I got to before, and we'll start talking about how justices sit essentially on key issues and how they work it out, what key issues go with what. So that's me done. I hope that has been useful for you, and I hope that you found something useful in that video that may help you with your work today. One last thing before I go. I am going to set this as an assignment so I can see who's accessing these. I know some people replied to me yesterday because I put the link in here. But where is it? Here it is. But I am going to see. I'm going to set it as an assignment so I know who's having access to it and I can contact people if they need help. Okay, I think that's me done. So until tomorrow or until the next couple of days, it might not be completely tomorrow. I hope you are doing okay. Stay safe and see you later.